Hello friends, I am Rajinder Goyal. On the last date, in the last session, I have discussed with you with regard to chapter 2 as it relates to boundaries. And as I have already said, land is a three-dimensional concept and boundaries is of two types, horizontal and vertical and lateral. Horizontal is, I have already explained. Vertical, I have already explained with regard to the other factors. Now today, I am going to discuss with regard to the third concept, lateral boundaries, with regard to the land bounded by water. That is also one of the concepts in the boundaries. First of all, if we can discuss basically land bounded by water, that relates to some definitions. First off is riparian rights. Now what is riparian right? A riparian owner is anyone who owns a property where there is a water course within or adjacent to the boundaries of their property, and a water course includes a river, stream or a ditch. A riparian owner is also responsible for water courses or culverted water courses passing through their land. Riparian rights are basically the traditional rights that attach to waterfront by virtue of that property actually meeting the shoreline. They are the rights of waterfront property owner to gain access to the water or to gain access to their property from the water. Now, what riparian rights generally we can say? Basically, these are usufructuary rights, rights of use, as you know. So, the second part I would say is what are the rights with regard to access to water. First right is right to take emergency measures against flooding. The second would be appropriated unlimited amount of water for ordinary uses. Then is extraordinary purposes like manufacturing or crop irrigation, limited to conserve water for riparian tenants downstreams. Flow of a river cannot be diminished so as to quality and quantity. Now the riparian rights were thoroughly discussed in one of the judgments by the Supreme Court of Canada. The judgment is Epstein versus Reims. That was in 1973. Basically, that judgment had laid down what was in Halsbury proposition, and it says every riparian owner on a natural water course flowing in a known and defined channel, whether on the surface of the land or below it, or in an artificial channel of a permanent character, has as incident to his property in the riparian land a proprietary right to have the water flow to him in its natural state in flow, quantity and quality, neither increased nor diminished, whether he has yet made use of it or not. Now the weight of this authority that riparian rights exist in the flow of artificial streams, where the artificial condition where the artificial condition has a permanency, and lower riparian rights have relied upon its continuance. Now, intentional interference with this benefit without justification is a actionable tort, and redress is injunction, which is an appropriate remedy. The absence of physical injury or property damage does not affect the right to an injunction where there is a conduct not merely temporarily which materially interferes with the comfort and enjoyment of living in the locality. Now the second part would be with regard to alluvion and diluvion, basically accretion of land and decretion of land. Now erosion of the bank on one side and formation of char on the other side are the recurring acts of river systems. Such loss of land mass, which is called diluvion, and formation of chars, which is called alluvion, an accession to land by the gradual addition of matter as by deposit of alluvium and then belongs to the river of the owner or to which it is added also the land so added. So if there is a alluvium and a land is accumulated near the land of a owner, his land increases. He has a right over that. And what is evolution? And the sudden decrease of land by flow of a water, the land is decreased. So he loses that right. But once again the charge deposits and the land increases, he gets that right. So that is alluvium. Now, what is accretion? Accretion is the process of growth or enlargement by a gradual build-up. Alluvial means an increase in land from the flow of water against a shore or bank. Now the third thing would be with regard to the rights in the boundaries. There are two definitions, tidal water and non-tidal waters. And what are the rights of a landowner whose land adjoins a water course with regard to tidal and with regard to non-tidal. Now first of all I will be discussing the tidal water. Tidal waters are all waters downstream from an inland water boundary, often referred to as head of tide. A tidal river is a river whose flow and level are influenced by tides. Water flow and level fluctuates with the tides. Basically, tidal rivers are navigable. Ownership, now the chapter deals with boundaries and what are the rights of a owner of a land whose land adjoins a tidal water. Now, with regard to tidal waters, it says ownership extends only to the ordinary or mean high water mark, and between the high and low marks, the foreshore also belongs to the state. There is one judgment with regard to this navigability, that is R versus Nickel, and which deals with these things. And it says ad medium film eque rule doesn't apply to navigable rivers in British Columbia, MB and Alberta. For navigability, it is the river as a whole from its mouth to the point where its navigability terminates that must be considered. Now with regard to non-tidal waters, what are the non-tidal waters? They are typically areas where the water table is at or near the surface or the land is covered by shallow water. Non-tidal areas are those where the tidal range is less than 1 feet or 0.3 meters. Now presumption of ownership not easy to overcome in these matters. Owner of a river island would hold title from the shore to the center of the beds on both sides of the island. The boundary of land that is adjacent to a non-tidal river extends to the middle of that river, which is the Latin maximum ad medium film eque, unless there is exception to this also. That exception can be created by the state, by a document of the state, and this has been dealt with one of the judgments, R versus Bryan in 1981. Now the word accretion, I would be again repeating accretion. Accretion is growth or increase of land by gradual accumulation of additional layers or matter. Accretion may occur either by gradual deposit of soil or sand, by permanent recession of water, includes erosion, encroaching, advance of water's edge, diluvium, recession of water. Accretion is an inherent riparian right, but its operation may be excluded in the granting document by the state, which is Crown. If accretion is gradual and imperceptible, recognizes a distinction needs to be made between progressions where one riparian owner gains and one loses. There is a judgment on this aspect also, that is Southern Centre of Theosophy, NCA versus State of South Australia. But if accretion is not gradual and imperceptible, then sudden evolution does not affect accretion or erosion. Now the question would be, where it was rapid, the original location of land still defines the boundary. So it must be a slow process. It should not be rapid. To give riparian owner benefit of access to water, sudden evolution does not affect erosion or erosion. Now this was held in Cox versus Prestres in 2001. That is a judgment. Another judgment I would mention here is that Nastages versus North Alberta Land Registration District in 1989, where it was held that law of accretion only applies to riparian owners, that is, land adjoins water, and if not riparian owner, then it belongs to Crown. If the land extended due to receding shore, landowner's title extend to it as long as newly exposed land is connected. Property must run to shoreline. So this is the basic introduction with regard to the land bounded by water, and you have to thoroughly go through the definitions of riparian owner, the alluvion, diluvian, accretion, decretion, in order to gather and rather answer the question with regard to the property rights of a owner if his land adjoins a water course. So you have to also go through the judgments which I have just mentioned in this session. Thank you very much. If you have any query, you can contact me on my WhatsApp number, that is +91 98140 33663. You can also subscribe this video, and you can also watch this. And if any of you have any query, any doubts with regard to property law, feel free to give me a message on my WhatsApp number so that I can give you a time you can discuss with me. Thank you very much.